Hi, my name is Eric Willison, and this is Fatlock on Evidence. We left off last time working our way through the hearsay exceptions that are in the rules of evidence, and we're coming across another one, which is found under Federal Rule of Evidence 803, subsection 5. Now, we're going to jump around a little bit within the numerical sections here, but this is what's called Past Recollection Recorded. And what the rule says, and I'm going to read it verbatim, FRE 8035, recorded recollection, a record that A, is on a matter the witness once knew about but now cannot recall well enough to testify fully and accurately, B, was made or adopted by the witness when the matter was fresh in the witness's memory, and C, accurately reflects the witness's knowledge, then that can be brought into evidence in a way. We'll get to that in just a minute here. An example of this, well, it says, let's finish off the rule here. If admitted, the record may only be read into evidence, but may be received as an exhibit only if offered by an adverse party. So if you're trying to admit it in and it meets all the requirements, then you can read the record into before the jury or the judge. But you can't actually mark it as exhibit so-and-so and have it put into evidence. So that the jury can take it back into the jury room and consider it when making their decision, or the judge can take it back into chambers to think about as far as deliberation goes. Examples of this might be a police report when the policeman, maybe it was a long time ago, and the policeman can't really remember the details of a traffic crash. So the police report can come in, a diary that a person wrote back when they were a kid, and they can remember some of it, but they can't remember all of it, then maybe the diary could come in because it's a better recollection. Maybe notes taken during a meeting could be something that could come in under this. Now there's 4 requirements here, and they're all in the rule, but I'm going to sort of read them as 4 separate requirements as opposed to the A, B, and C's, so that it's a little bit easier to think about them that way. The first requirement is first-hand knowledge. The person that is talking about the testimony and saying, gee, it sure would help if I could, and I can't really remember it, but I've got that record out there that I made, and that would really help me, then you got to have first-hand knowledge. You can't be somebody else and say, gee, I remember this guy told me all about this, and gee, he had a diary entry, I could read that. That would sort of make things more complete. That's not going to work. The person who's testifying has to have first-hand knowledge of it. Now, number 2, when the person recorded the memory all those years ago, or all those months ago, or maybe even all those weeks ago, if things are really, really busy and you can't always remember what happened, the person has to have recorded it when this memory was still recent and fresh. Now, the common law rule, before the rules of evidence came in, it had to be really fresh. It had to have just happened, and you jotted it down, okay? But with the federal rules of evidence and the Ohio rules of evidence, that's expanded a little bit more so that maybe a few days or even a week can have passed, so long as when you wrote it down, you could still remember it very, very accurately. So it's got to be fresh in the memory, okay? That's the requirement number 2. Requirement number 3 is that your memory, in order to get that record in that you jotted down when it first happened, to get that in, you have to be able to testify to the court that there's something a bit wrong with my memory about this. There's stuff I'm leaving out. I know I'm leaving important stuff out here because I just can't remember it very well. There has to be some sort of an impairment in the memory. Now, under the common law rule, the impairment has to be so bad that the memory you can't even remember anything of it. But the federal rule of evidence rule and the Ohio rule of evidence rule just says the impairment does not have to be that bad, but there does have to be an impairment. Now, why do we have this impairment rule at all? Primarily because of the fact that you don't want people who are going, that might come up in court someday, so I'm going to write this little thing down And they're really writing it down in anticipation of what, of some future testimony, when the courts don't want that. So what they're doing then is it only comes in if you are showing some sort of an impairment a long time later after, and just, I can't remember whether she came in first or whether her friend came in first. I can't remember, but I know that I wrote that in my diary, and I know that that's in there, and that can give us an accurate picture of things. So now we've got that impairment. That'll be the third restriction, or the third requirement, I should say, to let it in. And then the fourth one is that, well, let's see, where did it go? The fourth one is it has to be accurate. The note taking, we talked earlier about how it had to be fresh, but the fourth requirement is that it not only had to be fresh, but it has to be accurate. For instance, it can be fresh in your memory, but you were so excited, or you were so drunk, or you were so this or that you're not writing it down as it actually happened. You're leaving it to your imagination or something else. So the recording has to be accurate. Now, you can even meet this requirement by saying something like, gee, I don't remember specifically if the statement is accurate, but I had a practice at the time that when I wrote these sorts of statements, I only wrote what was accurate. I didn't write anything else. So for instance, this is a bad example because as an attorney, anything a client says to me would be confidential. There'd be a duty of confidentiality, and there'd be a privilege against me talking about it. But let's say that privilege has been waived or something like that. When I see a client, the first thing I do, or when I get a phone call from a client, the first thing I do is I reach for my notepad and my pen, and I start scribbling notes of what that person told me as I do it, as he speaks. Now, I know that I can't get everything verbatim because I can't write that fast, my hand will fall off, but I put enough on those notes that I know that as soon as I hang up the phone, I get on my computer and bang, I type out a memo of what was said from my notes. So now I can sort of flesh it out because I've got a few extra minutes now. The guy's not on to some new idea. I've got it all recorded already. So I take my sort of skeletal outline that's in pen and ink, and I put it into a digital format now that is much more detailed in what he said. So now if I go back 3-4 weeks later, 3-4 months later, that client calls back and says, hey, remember me? I can say, hold on a second. I remember you perfectly, Aunt Marge. There it is, you see. So that would be something that I could testify that I'm very careful with that, and I only record things accurately when I do it. So now, if all these requirements are met, then the federal rule and the Ohio rule says that the witness can get it in, but only to read it into the record. In other words, it's not going to become its own evidentiary exhibit marked Defendant's Exhibit B17, and then the jury will take this back into the jury room and consider it along with other things like a bloody knife or a picture of this or a video of that. No, it's not going to be marked as an exhibit unless the other side of the case says, yeah, we agree that can come in as a marked exhibit. So what will happen is, in most cases, it'll just be read into the record by the person who is on the stand, and they will. That's how it'll go in. Now, there are very few courts that will just allow this sort of thing to go into evidence, but the vast majority of these things, it's just going to be read into the record. Okay? Now, this is sort of like some other exceptions that we're going to get into. Like, there's something called the business records exception. And when you start hearing about the business record exception, you're going to say, how is this different than the past recollection recorded? Why do we have a whole new exception for this? Well, there are some differences. and we haven't gotten into the business records exception already, I'll just give you a very, very broad look at it. If in the course of your business you make reports and inventories and things like that, if you're a psychiatrist and you jot down what people say to you so that you can treat them and all that kind of stuff, it's a record of your business, and the keeper of the records can testify that this is accurate, and therefore it can come in and not be hearsay. Now, that's sort of like this, but we've already seen how the requirements are a little bit different. That business records keeper may not be the person who actually jotted down the record, so that would be a different requirement than this. Also, with the business records examination, the witness who wrote down the recorded statement for the business does not have to be there to testify. Only the records custodian does. Whereas with a past recollection recorded, the witness who wrote down the thing and made the record does have to be there. Now, there's also some other aspects we have to think about. There's something we haven't gotten into yet. It's also called the best evidence rule. That's going to apply to these records. And the best evidence rule, and I'm just going to summarize it right here very, very broadly, is that the original record has to be introduced, not some photocopy of it, unless the person who's introducing that piece of evidence says, you know, I had that thing for the longest time, and then Hurricane Eloise hit back in 1974, and it totally flooded out the back office room, and everything was destroyed, but my copies were over at the office, and so that's all I can give you is the copy. So for no fault of the declarant's own, or the witness's own, the originals were lost, then the copies can come in under the best evidence rule. Now, there's a lot more to it than that. I'm just giving you that, but the best evidence rule does apply to these sorts of recorded statements. Now, also, it doesn't actually have to be a writing. You know, most people, they just have they take out their pen and their paper, or they type something up real quick on their computer, and so there it is, they can print it out. But, you know, you can have one of those little, you know, dictaphone things, or voice notes recorder on your phone or whatever, and you can just have an audio recording. Maybe you recorded the meeting, you took out the little tape recorder, or you told the person, hey, I'm going to be recording this so that there's no issues about what was said, and you hit voice notes. Now, do I have your permission to record this? Yes, you do. Now that could be the past recollection recorded that meets this exception. So it doesn't necessarily have to be a piece of paper with writing on it. Now, there's also one other thing, which is that sometimes people will say, I want to introduce this document, Your Honor, to refresh my witness's recollection. And you're thinking, well, how is that different from past recollection recorded? Well, it is different. There's some things that are the same, like the fact that there's an impairment of the memory, but the document that can be used to refresh the witness's recollection could be anything. As a matter of fact, didn't have to be a document, it could be like a stuffed animal. Does this help you remember this stuffed animal? Oh yes, now I remember, it was Winnie the Pooh was my stuffed animal. Yes, I remember that. Or it could be somebody else's statement, and the more the person thinks about it, you know, now I remember. Because memory is sequential in human beings. You know, when you first start thinking about things going back in time, you may not remember them, but the more you talk about it, the more you remember, okay? And so sometimes you just don't remember, and see, I can't remember whether that was the Atlantic Ocean or the Pacific Ocean, and then somebody breaks out a picture of that person right around that time, right around that month, and there's a bunch of rocks all over the beach, which is sort of indicative of the Pacific Ocean beaches, whereas the Atlantic Ocean beaches maybe are more sandy, okay? So they might look at it and go, yes, now that reminds me. As a matter of fact, now I remember. We drove all the way to New York and drove all the way out to the tip of Long Island, and that's where we went swimming that day. Now I remember, because they saw that picture, okay? So that's past recollection recorded, but that picture was not a recorded statement of anybody, and the person is depicted in the picture, so that person, she could not have been the person who made the picture. In the past recollection recorded, the person who's remembering has to have put this together. And there's one very minor exception to that too. If you're a really important person, let's say, and you do recorded notes of voice notes of what you're doing, and then you turn them over for transcription to your assistant or something like that, and then the assistant types them up. The fact that the assistant typed them up, that doesn't mean that that's not your statement. It is your statement. It's just that the assistant is typing up what you said. So it doesn't specifically have to be handwritten by you. Your secretary could have been writing something down for you while you made these pronouncements about some wonderful piece of art, and this is all going to be in a story in the magazine that you're writing that month. And so she's just writing down what you're saying, but you still said it, and it's so you don't have to be actually the person who physically did it, although in most cases you are. So that is the past recollection recorded exception to the hearsay rule found at Federal Rule of Evidence 8035. You want to check your own state's rules, because Ohio's is word for word the same, but there are some exceptions. There are some differences from state to state in those rules. I'm Fatlock on evidence.